Good evening, everybody. I think we're going to make a start now, and some people may still join as we are speaking. As I mentioned earlier to a few of you, my name is Danny. I'm the Head of Communications here at the Embassy. I'll be moderating proceedings this evening, but the main presentation will be conducted by Ambassador Fazel and my colleague Sandra, who is our Diplomatic Attaché here at the Embassy. And as I say, they'll begin with a presentation that goes through the main topics, and then later in the session, there will be a Q&A session. So could I ask you all to please post any questions that you have in the chat function at the side of the box. And as I mentioned earlier, please keep your cameras and microphones switched off at all times and only use the chat function to communicate, because we have a lot of participants in this meeting. Now, without further ado, I will hand you over to Ambassador Fazel to give the opening remarks and talk us through the agenda for today. Over to you, Mr. Ambassador.
Thank you very much, Danny, and welcome to you all, dear fellow compatriots and residents in the United Kingdom. I'm very happy to welcome you here. Thank you very much for your interest and participation. I think it is a very good moment to congregate as we start emerging from the COVID-19 pandemic, and what extraordinary time this has been under a number of aspects. COVID and the life we have had in it provided us with a lot of difficulties, but has also created and shown us a number of opportunities. I call that the Brexit paradoxon. So on one hand, the hands face space thing, and the whole social distancing as a social act, indeed, as a community act, because by distancing socially, we are providing protection to one another. But this distance then is driving us apart into some degree of isolation. But then at the same time, the distancing has driven us towards new forms of community and congregation, such as this team event today. I don't think we would have been able to convene 300 participants in the lecture hall of the Embassy. That would have technically not been possible. So let's accept that there were a few positive aspects to this experience in the end. But when I say extraordinary situation, which is also a situation with the COVID pandemic, which has put aside other elements we need to focus on. We have mainly been concerned with Brexit, with the Brexit restrictions, with travel restrictions back and forth to Switzerland, which you know well and have been quite problematic. But all that has obscured a number of questions of immediate interests that merit our attention around Brexit and the aftermath of Brexit, which we need to focus on. So it is mainly about the immediate impact of Brexit on the rights of Swiss citizens residing in the UK. And you remember that what the Swiss government wanted to do, and actually has achieved to do, is to make sure that the legal position of all the citizens and economic operators in the UK and in Switzerland remains unharmed by Brexit, so that we can roll over our bilateral relationship into the new world. And this is, as far as citizens' rights are concerned, is something we have managed through the so-called Citizens' Rights Agreement. So your rights as citizens here in the UK are fully safeguarded, and you will be able to continue your life here on the basis of a status that is called settled status. But there is no automatism there. It's not automatic. You need to apply for this status, and you need to apply by the 30th of June 21. There is this deadline. A fair share of our compatriots have applied and have received the status, but those who haven't should now do it, not wait to the last moment, and also see whether friends, family, acquaintances out there who have not signed up and applied, that they follow their lead and do that in time as I said, 30th of June 21. So today we would like to go through this settlement scheme. What is it exactly? And then discuss the questions and provide answers to the questions you are sending us in the chat box. And in this spirit, I would like to hand the floor to my colleague Sandra. And Sandra, could you please talk us through the technicalities of the Citizens' Rights Agreement and what that means for our fellow Swiss citizens in the UK, please?
Good evening, everybody. My name is Sandra Imhoff, and I've been working on citizens' rights issues over the past few months for the Swiss Embassy in London. After these introductory remarks from Ambassador Fazal, I will provide you with some background information on the new residence rights post-Brexit and attempt to competently answer the questions you might have with regard to the EU settlement scheme and or the application process. As the ambassador has just pointed out, the transition period based on the UK EU withdrawal agreement ended at the end of December 2020, and the UK has now fully exited the EU. Therefore, Switzerland had anticipated and negotiated the Citizens' Rights Agreement in order to safeguard your rights as Swiss citizens acquired under the Free Movement of Persons Agreement. The agreement was part of the Swiss government's Mind the Gap strategy, the purpose of which was precisely to ensure the acquired rights and obligations of citizens after Brexit. The agreement, which has been applied since January 2021, basically constitutes a replica of the UK-EU withdrawal agreement. To secure your rights while living in the UK has launched the new residence status called pre-settled and settled status, which need to be acquired by applying, as has been said, to the EU settlement scheme. While the final deadline for application has been set to be the 30th June 2021, the Home Office has recently published a list of reasonable grounds which it will consider in case of late applications. However, we strongly recommend that you apply as soon as possible, as there may be delays with regard to the application process, and without digital proof of your residence status, you could potentially face difficulties with regard to employment or rental contracts. Next slide, please. On the next slide, you have an overview of some key figures regarding the EU settlement scheme. It's interesting to note that to date, the Home Office has received over 5 million applications for the EU settlement scheme. In comparison, by the end of March, there had been 16,980 applications to the EUSS coming from Swiss citizens living in the UK, of which a total of 15,740 had been concluded so far. Interestingly to note also that among them 7,140 were granted settled status, while 6,540 were granted pre-settled status. Also important to flag that the EU settlement scheme is run and coordinated by the Home Office. Next slide, please. The new post-Brexit residence status that the UK launched is called settled and pre-settled status. And for you to remain in the UK, you have obviously to apply to that. So if you have lived in the UK for a continuous 5-year period, continuous residence, you should be granted automatically settled status. The Home Office interprets continuous residence as meaning that you have been living in the UK in a row for at least 6 months in any 12-month period. Except obviously, if you have been absent from the country for an important reason, which might be related to childbirth, serious illness, study, vocational training, or an overseas work posting. Otherwise, you will be granted automatically this settled status. Once you have been granted this status, you only need to make sure that you keep your online status up to date. Namely, if you receive a new passport or a new identity card, or if you change your name, your email address or your UK address. However, if you do not have 5 years of continuous residence when you apply to the settlement scheme, you will usually get what is called pre-settled status. This will allow you to stay in the UK for further 5 years from the date you get pre-settled status. Once you have accomplished a 5 years continuous residence, you can then apply for the settled status. Finally, it's important to note that you will be issued only with digital proof of your settled or pre-settled status in case of successful application through the scheme, and that at no time you will be given any physical proof of your settled status. Next slide, please. There might be some confusion as to the rules which are applicable in case of dual citizenship. If you have dual citizenship and, for example, you hold a Swiss and an EU passport, you may decide whether you want to use your Swiss or your EU nationality to submit your application for settled status. However, you have to opt for either or. When making your decision, you might want to consider the following differences between settled status under the Swiss regime and settled status under the EU regime. While the Swiss settled status is more generous with regard to family reunification of future spouses, for example, third country nationals who become the spouse of a Swiss national after the end of the transition period can join the Swiss national already living in the UK for a period of up to 5 years until 2025, whereas the UK-EU withdrawal agreement does not provide for this. However, in turn, the EU settled status is more generous with regard to the authorised period of absence from the UK. With Swiss settled status, you can be absent from the UK for a period of up to 4 years, while with the EU settled status, you can be absent from the country for a period of up to 5 years without losing your settled status. If you are a Swiss-UK dual national, as is mentioned here, you cannot and you need not apply as you already enjoy full residence rights. Next slide, please. Family reunification is obviously an important issue to be considered and is also covered by the Citizens' Rights Agreement. Important to note is that spouses, civil or unmarried partners may join their partners already living in the UK until the 31st December 2025. So they have 5 years to join their spouses if the relationship began by the 31st of December 2020 and obviously still exists when applying. Family members who were living with Swiss citizens in the UK before the 31st of December 2020 can also apply for settled or pre-settled status. However, please note that they can do so only if they have started living in the UK prior to the 31st of December 2020. So there are numerous conditions which apply, but it is quite straightforward if you can prove that the relationship already existed prior to you coming or prior to your family member joining you in the UK. So this also applies to family members who were not living in the UK by the 31st of December 2020. They can still apply if, again, the relationship existed and still exists when applying. So, and they would then qualify as close family members, for example, as spouses, civil partners, unmarried partners, but also dependent child or grandchild or dependent parents or even grandparents. Finally, children born or adopted after the 31st of December 2020 will also have their rights protected under the Citizens' Rights Agreement. Next slide, please. As regards the immigration status, there is no formal requirement to apply to the EU settlement scheme if you have indefinite leave to enter or remain, also called or known as ILR. ILR is equivalent to settled status under the EU settlement scheme. Up to now, the UK had a similar immigration status called indefinite leave to enter or remain, ILER. So this might be a bit confusing, but this status granted permanent resident status in the UK. While this resident status does remain valid, and that's really important to highlight, a new immigration status under the EU settlement scheme does provide you with a couple of advantages, and this will allow you to spend, as already mentioned, up to 4 years in a row outside the UK without losing your settled status. So if you choose to change your ILR to settled status, the application for settled status should be a simple process and subject only to verification of identity and a criminality check and confirmation of ongoing residence. The other advantage, obviously, is that it does provide you with secure digital evidence of your immigration status. In line with the Home Office guidance that has recently been published, you can make a late application to the scheme if there are reasonable grounds for missing this June deadline because, for instance, you were not aware that you were eligible for the EU settlement scheme in that case. Should you, however, decide against applying for settled status, if you have ILR, please note that you should ensure that you have sufficient proof of your ILR status. There is also a final aspect with if you have lived in the UK before 1973 and you were automatically granted ILR, you do not need to apply to the EU settlement scheme for settled status. If you do not have a document confirming this status, you can either apply for the settled status or what is called and known as the Windrush scheme to get proof of your ILR status. Next slide, please. And this already brings me actually to the final slide in which I would like to convey the following message. Don't be late and remember that date. We strongly hope that the information that we are providing during this webinar is useful and relevant to you, and we would kindly encourage you to apply as soon as possible if you haven't already done so in order to secure your residence rights in the UK. Furthermore, if you need any assistance or help with regard to your personal situation, please check the information on our website and on the Home Office website and our Brexit FAQ. Also, if you have any queries regarding your personal situation, there is the EU Settlement Resolution Centre, and you could also feel free to contact us for any support you might need in that regard. And on that point, I will hand over to my colleague, Danny.
Thank you, Sandra. Hopefully that gave a bit more information that was helpful to people there. As I say, we can clarify any particular points afterwards if needed. We have tried to address as many issues as possible tonight. I hope we have covered many of the questions and queries you had. As I say, we unfortunately haven't got time to go into specifics on every particular detail, but I will now post an email address in the chat that you can use to follow up with us on any of the points covered tonight or anything that comes to mind following the meeting. But with that in mind, I would now like to hand over to Ambassador Fazell to give the closing remarks. Thank you.
Thank you, Danny, and thank you, Sandra, for all those elements, and thank you to all of you, dear participants. Thanks for your interest and presence today. I hope we were able to provide information and to clarify the situation. If you still have questions, please go to the Home Office site or contact the Settlement Scheme Resolution Center, or consult the frequent asked questions on the website of the embassy. You can also, if you are really hard pressed, you can call in here at the embassy and we will help you and direct you. You can also ask for the help of the Swiss Benevolent Society if you have difficulties dealing with all those internet things, because of course the whole application for the settlement status is web-based, must be done through the internet. So the Swiss Benevolent Society provides help there as well. But whatever you do, please remember the deadline. It is the 30th of June 21, and don't wait for the last minute. Please go and do apply, and tell all your friends and families and acquaintances who have not done so to do as you will now, that is to apply for the settled status. And with that, I wish you a wonderful evening. I hope that some of you will be able to indulge in this new favorite British pastime, which is the alfresco dining. And in this spirit, je vous souhaite une bonne soirée et au plaisir d'une prochaine rencontre. Goodbye.